MCK will be appearing at the Supreme Court of Canada in Ottawa on Wednesday, November 30th. This in regard to the National Energy Board and its processes regarding consultation and accommodation of Indigenous people and groups. Francis Walsh is a member of the MCK Legal Services Unit. He'll be making the presentation on MCK's behalf, and KTV spoke to him about this important event.
The court case essentially is an appeal that was filed by the Chippewa of the Thames First Nation against the National Energy Board's approval of the Enbridge Line 9B pipeline project. And the key question that's going to be assessed by the Supreme Court of Canada is whether or not the board's decision is invalid because it failed to assess whether Canada met its consultation obligations to the Chippewa prior to rendering its approval of the project. So the MCK is intervening, felt that the issue is very important regarding the duty of consult in this country, the duty to consult Indigenous nations in this country. So we decided to intervene in favor of the Chippewa in this case. And we want to make sure that the Supreme Court of Canada really reaffirms the importance of the nation-to-nation relationship in approving a large projects such as pipelines. The important thing for Kahnawake is for the Energy Board and the Crown to understand that the Energy Board process can't address all potential adverse impacts of these types of projects on the rights of Indigenous peoples in this country. So what the important thing to recall is that there needs to be direct Crown engagement between First Nations and the Government of Canada to discuss these projects prior to them being approved. I think that the decision that's going to come from this case is going to be really key in determining the type of administrative review processes that the government can put in place and the role that the government needs to have in engaging directly with Indigenous nations as part of those review processes. So to what extent can they rely on administrative boards to discharge the duty to consult the First Nations without engaging directly with Indigenous nations? And that is the key question I think that this appeal will determine, and it's going to have a big impact on how administrative boards are set up in the future and what their role are going to be with respect to consultation. And for Kahnawake, the important thing is that the nation-to-nation relationship doesn't get lost when the government does establish these administrative board processes.